So yeah. All right. Sorry, I was just chatting away there for a second. It might help. A lot of people find that they hear better when they don't have their videos on as well. I don't know if it's a bandwidth issue but it is very strange for me just looking at a black screen. I'll stop complaining about that.
If anybody's on the 2.4 bandwidth, maybe switch to 5 because my 4 doesn't even want to load into the Collaborate Ultra screen. Like, couldn't even load in, so.
Please, Michael, don't apologise for having Mother's Day commitments. I think everybody should be nice to their mother.
Thanks, Catherine.
And yeah, and really these tutes they're only here for people to ask questions and to deal with what they need to deal with. I was a bit surprised that I saw anybody here today because you guys have got you got things to do. Most of you have got an assignment due today, I know. Hey, Elliot, nice to see you. Yeah.
Hi.
Nice. Did you make something for your mum? That's my favourite thing. Yeah, what'd you make?
Did you make something?
Not really.
No.
Not really.
No.
Not even a piece of toast?
No, I don't even know how to make toast.
Don't you? Oh, well, we'll have to work on that.
Yeah.
All right, we're here for questions. I shouldn't be asking Elliot questions. I should be asking the rest of you questions or finding out how I can help. So, what do you guys need from me?
What does just a second, I'll look quickly. What does PER mean?
Parole evidence rule.
Oh, right, okay.
So, yay, a question I can answer first go. Yes, so Gabby, you've got a question. Sorry, I was too busy admiring, Gary was in here first, and I was too busy admiring her post-it notes on her window. So off you go, Gabby.
I'm wondering, I just didn't totally get my head around the statute on frauds. So if for instance, you said like all the particular sort of general things that are covered in the statute of frauds are now specific to states and territories. Can you hear me okay?
Yeah, I can hear, I'm listening. I was also muting Sarah. I hope you don't mind, Sarah.
So for instance, if in Victoria a particular issue is not covered, is not relevant to that statute of frauds version that is Victorian, then we essentially can disregard it.
If everything happens in Victoria. So the point is that the common law, if we just pair it back to the key principles, the common law requires that you have all of the elements present in order for there to be an enforceable contract. So agreement, consideration, intention, and certainty. None of those things are writing. Subsequently, in 1677, the relevant Houses of Parliament passed the Statute of Frauds, which said certain types of contract need to be in writing. Subsequently, there have been many successors to that statute, and the equivalent in Victoria now is the Instruments Act, but it's been much whittled down. And in addition, new things have come up where the legislature has required formalities of some sort. So, for example, requirements under the Australian Consumer Law. So that's a national thing. So for door-to-door sales, for example, or also state by state rules relating to motor cars, which clearly weren't around in 1677. We haven't forgotten your racetrack, Elliot. So it's not so much, the process is, do we have a contract? If you have a contract, what's the subject matter of that contract? If the subject matter is something where a formalities requirement comes in, that will be different in one state to another state, one country to another country.
Okay, but there's nothing, for instance, it sort of says that the things that are covered by statute of frauds are relatively arbitrary, like it's just someone just chose what things were going to be covered by it. But so there's what's been said in the lectures and in the book are the only things that are covered by the statute of frauds.
Yes. So the statute in the lecture, I listed out the original things, and in the materials I've listed out the original things. In New South, from memory, I'm going to be terrible on the states, but in New South Wales, from memory, pretty much all of them have gone except for land. In Tasmania, pretty much all of them are still there that they're allowed to have. In Victoria, the two big ones that we have are land and guarantees. And as a sort of byproduct, if you are appointing somebody to act as your agent in relation to land, that person has to be appointed in writing too.
Okay.
Yeah.
Great.
Easy peasy. Oh, there's a taller version of Elliot here to visit us as well. Hi. Next question. What have we got? I always feel like I'm, on the chair. Marius, what can you?
Can we maybe talk about just about the illusionary promises? Because if someone goes and be like, okay, well, if they say something like, oh, I don't want to be held to this, and then so basically, how do I put this? Is it different things like honor clause and illusionary promise? Is it separate things, or is it basically
separate things? That's what I was just listening to the way you were talking about. I was wondering, are you talking about an illusory promise, or are you talking about a promise that is an honor clause or a promise given in honor only? So an honor clause is really a promise that's made where it's very clear that there is no intention for it to be binding. So the examples are things like that MMC case, where the parent company was originally asked for a guarantee for an actual enforceable security, and they said, no, we will not give you that. It's our policy to support our subsidiaries, but the whole reason that we've created a separate subsidiary for doing this trading on the tin market is because we want to separate the risk out into that entity. If we were prepared to take all of the risk, we would just do it as a separate business within our group. And so we don't intend for it to be binding. They were very clear about it, and it was just, this is, we don't want it to go broke. Our policy is to support it, but we won't do that at risk of anything else. So that was an honor clause. A illusory promise is a promise that's so discretionary that it's not really a promise. It's kind of like saying, I'll pick my words carefully. A version where an illusory promise, if the facts were different in MMC, and what they said is, yes, we will give you a guarantee, but that guarantee will be subject to a provision that will allow us to withdraw it at any time, including retrospectively. So that if you try and exercise that guarantee, all we have to do is give you a notice and say that we've withdrawn the guarantee, and that withdrawal notice can go back in time 14 days from before. So in other words, it's not really a promise. It's just they've got a mechanism that means they can withdraw at any time. So that's an illusory promise.
Okay,
that's not cool. Who's next? I'm worried that people are here procrastinating, hoping that they hear good questions rather than actually writing their assignments right now. But it's It's only because I have to wake up in the morning and read them.
Sorry, I have another question, if that's okay.
Yeah, that's great.
Just like I was reading I think it's a casebook. Is it, so Australia deals differently with honor clauses than they did in the UK? Like,
Excuse me. Thanks, Steph. So, can you expand on that? I haven't got the textbook. I haven't got the textbook in front of me. I just want to understand the reasoning there, because we did look at the two cases.
Yeah.
In the same year. One of them's an Australian case where it was found that there wasn't an honour clause, that the clause was in fact enforceable, and in the other they found that there was never any intention to be found. That's the UK case. Yeah. But I think the facts are consistent in those two cases. There was a subtle difference in the facts, that the law was effectively applied in a particular way. And it's important in the ANI case, that's the Australian decision, the Spedley decision, that ANI had made two promises. One was, or two statements, two representations. One was, it is our policy to support our affiliate company. And the other was, we will give you 90 days notice if we're going to cease being a shareholder. And it was really, it turned on that you didn't give us notice. By ceasing to be a shareholder and withdrawing your support, then the bank, I think it was Bank Brussels from memory, Bank Brussels basically lost its support in that way. And so that promise, MMC never gave that promise in the Metals case.
Okay, thank you.
So yeah, I wouldn't, yeah. I'm happy to have a look at the provision though that's talking, if the law is applied differently, I'll need to remind myself about that. And in some of these areas, the British decisions have been a little bit more narrow, but I think the concept's the same.
I'll look at if I can find it exactly, and then if someone else wants to.
Yeah, if you can find it exactly, if you can point to the statement, and we can unpick it. I'm happy to do that. But again, I'll tell you now, I've finally written that bloody exam. There are no questions. There will be no comparative law questions on it. So you will not be asked to tell me what the differences are between how something's done in the UK as opposed to with us in Australia.
Okay.
Now, that doesn't mean that it won't include a question where the UK deals with things differently. So like the Stedman and Stedman type situation where Australia has a narrower approach. It doesn't mean they will either, but you won't actually have to answer that specific comparative law question. I am a bit worried I made the exam a bit easy, but that's all right. You've got a doozy of an assignment to deal with at the moment, so it'll all work itself out in the wash. How are you guys going with the assignment? Seeing there's no hands up at the moment. Anybody having any fun?
Yeah, kind of enjoying the research.
It is good when you're challenged by it. I hope.
Yeah, and it feels useful to be practicing these skills. It doesn't feel like something, like separate to what will be practiced.
That's good. That's what I aim for. But now is probably a good time to tell me things I want to hear.
I'm getting used to the weird dopamine rush whenever you find something relevant. Like, like, oh my God, it makes sense. It fits.
And it will make sense.
Yes.
I'm happy to admit it's a slightly meaner problem than I've given it in the past. I think you guys are well and truly up for it. And I think it just requires that logic. It is very much like working in practice. And I also think if you hate doing this stuff, you're probably better off finding out in first year. So
very well.
Can you clarify what you said? I just didn't.
Mom, why are you lying to us?
Someone's got their mic on.
Yeah, I'll just have a look and see where that sound's coming from. Who am I?
That's better.
I don't know.
So did you say that an honour clause, if there's an honour clause, that doesn't mean that the promise becomes illusory? Those are like two separate things.
They're different things. They're related things. Illusory promises are more relevant to the consideration. So firstly, is it really a promise? Are you really exchanging something? But where we tend to bundle them up into the question of certainty. So if we think about certainty as one of the things that you need in order to meet the element of certainty, is we need to demonstrate that all of the essential terms are covered, so it's sufficiently complete, that all of the obligations are sufficiently clear. You can have a sensible understanding as to what each party's obligations are. And then lastly, that the promises are not illusory, which is in a sense another way of saying all of the essential terms are covered, because in order for all the essential terms to be addressed, we need to know what the consideration is. And you'll remember that really consideration has to move both ways, that we need an exchange of some sort. Now, they don't have to be adequate, but they need to be sufficient. So in exchange for my promise to dig your garden, you promise to pay me $1. So each of us has an obligation, me to dig your garden, you to pay me $1. And each of us has a right, me to receive $1, you to get some gardening done. And so if in fact your promise was, rather than I'll pay you $1, I will pay you an appropriate amount assessed by reference to your horoscope after you've dug the garden, possibly not sufficiently clear or able to be calculated. So that would fail for uncertainty. Or if it was, I'll pay you $1 million unless I decide not to. That's an illusory promise. It's I've got the right to withdraw that promise.
But isn't that sort of what the honour clause says? Because it says I'll pay you, but I don't have to pay you.
Yeah, well, yes, I can see that. But an honour clause it's really stated right up front, we don't ever intend this to be binding. This is just a statement of what our relationship is and our policy is now, but there is no promise that it is going to continue. And because the presumption is with commercial parties that there is an intention to be bound unless you are clear that you don't intend to be bound, really for an honour clause to be an honour clause these days, you have to be really clear that you have no intention of being bound. So ANI and Spedley Holdings is a good example of that. So just the additional promise of we'll give you 90 days notice or whatever that was enough to mean that it was that they found intention. Illusory promises tend to be framed a little bit, they're more complex, and they tend to be where a party is really trying to demonstrate, they're trying to be tricky often, and clearly get away with it. So I'm just trying to think of a good example of an illusory promise. Not sure that we actually ended up with a case on one, but where it's really where there is so much discretion that it's not really a promise. So they are promising, I'll pay you something, but it's really not clear what that something will be. They have absolute discretion to do so.
A bit like, Kath, the ticket case, was it the Mick Robertson or Mick something or other? The ticket case, they called that, they used the word illusory there somehow, because
Actually, that's good pickup, Sarah, because that one's right at the very beginning. So in Mick Robinson, the question went to where the contract was made, and I think Justin Stevens, don't quote me on that, his judgment went to that question of was it really a promise, because the disclaimer was so broad that really the airline wasn't making any promise to carry anybody anywhere.
So that would be an illusory promise?
It could be an illusory promise, yes. So there wasn't a contract. So the issue then was at what point that disclaimer was, the passenger was made aware of that limiting clause. And so we've seen that. And so sometimes the argument is, well, you couldn't add that clause in later because a contract's already been made. And even so, there's no consideration being given because there is no promise there. I saw Holly had her hand up before, and Marius either still has his hand up or has another question. But Holly, you have a question?
I do have a question, but I think I probably know the answer to it. I just
That's all right. Somebody else might.
If other people don't have questions, then I'll just ask it anyway. I am wondering, this is in regards to the this week's reading, but I think that it's also mentioned in earlier weeks. In this week's reading, they're just talking about the presumed intentions of the party the whole time. I'm assuming that that's like through the objective test. Like, can you synonymously use presumed and objective intention or not?
Yeah, they're not synonyms, but they're related concepts. So as
like, is there anything different in them?
As you apply the objective test, you look at what the parties have been doing and you make assumptions about what they mean, assuming that they're acting reasonably. You know, what would a reasonable person do or believe in this situation? And so we're talking about implied terms this week or starting tomorrow. And so the reading that you're doing at the moment is where the courts are looking at the conduct of the parties in order to make a decision about what the terms of the contract were to fill the gaps.
Yeah.
So I'm loving this corner of my screen over here. So we're talking, they're not the same concept, but they're related to each other. You can't actually apply an objective test without making an assumption because you don't have any facts. The facts aren't there to do that.
Yeah.
What you're doing is looking and saying, well, a reason, because we can't, and we don't use a subjective test. We don't ask the parties, well, what did you really mean with 2020 hindsight? We're making assumptions or presumptions. There's a really subtle difference between those two words. A presumption, when we use it as a lawyer, and actually I'm just realizing I'm about to, exercise my right to be the president of the Paduta Institute, pulled it directly out of my something starting with A. But this is how I've always understood these. I feel like I should get a dictionary, legal dictionary, and just check this. An assumption is used in the ordinary sense. I assume, based on not knowing anything else to be different, that, the person I was dealing with, who it turned out was drunk, they behaved like a rational, normal person. I had no ability to know that they were drunk, and I assumed that they were sober. Presumption is actually a slightly different thing. It's kind of the straw man, the hypothesis, if you will, that the law starts with. So when we're talking about a contract law dispute, there is a presumption that there is a contract unless one of the parties argues that, in fact, no contract was validly formed, which I know is 3/4 of this course, but most of the time when you go to court to fight about a contract, nobody is actually going through the formation arguments, right? Because there'll just be a presumption. Or there is a presumption that if we're fighting over the terms of a contract, that there was an intention that it be an enforceable contract. And so the party, if we're talking about a commercial arrangement, there's a presumption that it was intended to be commercial. That's overthrown very quickly by somebody actually bringing it into argument. And if it's a social or domestic relationship, there's a presumption like a starting point. So it's just a subtly different thing. I'm not being very articulate in the way I talk about it, but I think of them as slightly different things. We make assumptions, we start with presumptions. Marius, did you actually have a question, or you just hadn't lowered your hand? Because
no, my second point on the, so I found that piece about the, so this is in the case book, the new one, if you have this, I think, what's it called, the 14th edition.
I'm listening to you, I'll just grab it.
Okay, it's page 142, and it's in the judgment of the ANI at paragraph 524. It reads, the test prescribed by the law of Australia determined whether a statement was promising or only representational is different from that in England. This has been pointed out by McPherson J. in Nemeth and Baywaters Road Limited. It's Thomas said, and then
can you give me the page number again so I can just have a look at what you're looking at?
Sorry, 142 at the very bottom. It will be like paragraph 524.
142. Okay. Sorry, I'm just going to skim so I can have a look.
From what I got, it basically asked whether the promise can be treated as a warranty, or should it, like, can be taken as fact?
Yeah, yeah.
And
so I think really, I'll look at it more carefully and give you a more considered opinion on it, because it's not a point that's particularly relevant to where we've been, and so that's why it's not front of mind. I think part of this is because of when this case was, so this case is actually decided, I think, slightly before the MMC case in a different jurisdiction, and those two are more similar. What this is looking at now, and you're really good to be going back to that point, it's actually looking at cases we were discussing last week, is the Oscar Chess, and what was the other one? The Oscar Chess and the Dick Bentley cases on one hand, and JJ Savage, which is kind of the Australian version of that, on the other. And JJ Savage has a narrower construction, because JJ Savage, they found, even though the JJ Savage guys were speedboat experts, they found that the language that was used was strong enough, the Australian court said that strong enough that it was couched in the language of opinion, and that as a consequence, that representation about their opinion wasn't sufficiently promissory to be a promise to form part of a contract. And so where Lord Denning, particularly in Oscar Chess, had said, basically started with, you're a used car salesman. You should know more about used cars than this gentleman who's selling his mother's Morris. And so they had a broader test. So I think that's the distinction that they're looking at there in relation to the intention. But I'm going to post-it note and read it carefully when there isn't a whole lot of people and their cats watching me, and I will come back to you all if I don't agree with my own view. Is that all right? Question on notice?
Yeah, thanks.
Sarah, you've been waiting for a while. No problem, Gabby.
Can I ask a question, Kat?
Please, please.
Yep. So it was a case you talked about last week, I think, the seed case. Is it Wallace Son, that one? The delivering of the seed? And I didn't understand, I've read it a few times what was in the text, and I just don't understand how they described that one of the texts. It said that they said was that there was no warranty, express or implied, as to the growth, description, or other matters, or any other matters, right? And then it said that the court construed that strictly, so as excluding liability for breaches of conditions, like the one in question. And I just can't work out the way they phrased that. I can't work out what they're saying.
Yeah, it's true. I'm gonna have to go and get the words in front of me to follow it. But So the first question was, were the statements that were made about the seeds, the representations that were made before the contract was entered into, did they form part of the contract or not? And ultimately they found that they did not.
Right.
So they were, but that discussion was couched in terms of warranty. Now, I don't actually remember the condition that they were looking at.
It was
you guys are good. You really could.
Because they ordered one seed and they gave them another seed.
Yeah.
I just couldn't work out the judgment for it. And
so
about warranting.
So they ordered one seed, they got another. The question became whether or not there was a breach of the contract. That went back. It was the statement about the seed, the representation about the seed. Was that a promise that was made? They found that it wasn't. So my memory of how it actually worked was the question then became whether you got what? It wasn't onion seed, was it? It was flax seed or something. An onion seed in my head.
I can't remember.
No.
They seemed.
When I was a girl, the farm next to the farm that my uncle had, the guy grew onion for seed, basically, and he used to sell the seeds to Yates. And anyway, it's a terrible story. He had a sudden heart attack. He was only in his 40s, but he'd never labelled anything. And like this whole summer, they're just ready to harvest these seeds. And they've got experts from all over the world and in the farm trying to work out what kind of, because I don't know about you, but I can tell brown onions from red onions. I cannot tell one onion seed from another onion seed. And so as a consequence, that case is, like it just connects in your head. So you're lucky I didn't tell you about apricot drying. Nobody wants to know about that. So the original question is, were the representations made about the seed that gave them, that may have in fact led to the decision to buy the seed, were they representations that were capable of being relied on? When the answer to that became no, then that information didn't inform the obligation in relation to the seed that was delivered. So they got seed. It turned out that it wasn't seed like the way it was described outside of the contract, but that didn't matter because they got the seed. That's kind of totally oversimplifying it, but a lot of the time we've got to really pin down the language and understand how the end result occurs. But again, if you like, I'll go and have a look at the language and I'll write to you separately on that when it's not in.
Specifically talked about construing the term warranty strictly or broadly, and that's where I got a little bit confused between that kind of concept of whether it's construed strictly or broadly versus the other concept of a warranty versus a condition. And I couldn't work out the difference between those two concepts. Are they the same thing or are they different things?
The classification is different. So the classification is if it's a warranty, it's treated in one way. As you know, damages are the only breach. If it's classified as a condition, then you can terminate the contract. So that's one concept. The narrow or the broad is, if we're going to construe a warranty narrowly, then we're really only looking at, so in this case, and I need to look at it to remind myself properly, but the warranty related to the delivery of seed. And so if we construe it narrowly, it kind of sounds opposite, but if we construe it narrowly, it just means seed and nothing more. So any seed, you've met the obligation if you deliver the seed. Okay. If we construe it broadly, then what we're doing is we're taking in the other representations and we know it's XYZ seed. We're not relying on the words in the document. And then delivering ABC seed is a different thing.
Okay, you finally, now something's clicked.
So it takes me a while to get there, but yeah.
Kind of defining seed, now I get it. I have to reread it again now to see if I understand it when I read it. Yeah, thanks.
That's right, you've got helpers there, I can tell. More questions. Oh, we've got some, sorry, in the chat. Let me have a look. There we go. No, I had actually had a look at all of that. Okay, it's strange, this system. I can't actually necessarily see who's here. Victor, you haven't been, I haven't heard from you for a while. Have you got any questions for me? Anything in particular brought you here with us today? Oh, your mic isn't working. Sorry, and I'm putting you on the spot. That's not fair. Well, yeah. If we don't have questions, you know, we're at almost 8:10. I'm a bit inclined to call us to a close because I know you guys have got work to do. And I want to be helpful, not keeping you up later than you need to be kept up. Okay, well, unless we have any more questions, I can hear a rustle.
Thank you.
You all right there, Sarah?
Sorry, yeah, better get these kids to bed.
What about you, Big Elliot? Have you got a question?
He's disappeared. Right.
I don't know her name, so she became Big Elliot.
Ebony.
Ebony.
Yeah. Ebony. Right to Kat?
Nice to meet you, Ebony.
Bye.
Yeah, I just have
supporting your mum while she's working so hard to do her law degree.
Ebony still says, so what is it for? She doesn't understand what it's for. How to explain to a 4-year-old? It's like what you're supposed to do. That's what it is. That's what I say. It's what you're supposed to do.
Oh, jurisprudence will love you. Holly, you've got a question for me. Yay.
Yeah, it's just in relation to the case that Sarah was just talking about. I was under the impression from reading it that they were in a breach of contract, and I just Googled it because then I reread the sentence and I didn't really get it either. And simplestudying.com is telling me that the sellers were in breach of the contract.
I'm obviously relying on I don't rely on simple studies.
Yeah, nor do I. But I don't.
But I'm relying on my memory, which is possibly less reliable than a Google search. It's Wallace, isn't it?
Wallace, Sun and Wells versus Pratt and Haynes.
And Pratt and Haynes.
Yeah.
Wallace. Why can I not find it in the textbook?
It's on page 331 in the textbook, but I have the 5th edition. I don't know if that's an older version.
Is that in the casebook or the textbook?
No, in the textbook.
In the textbook. It won't be far away. I just can't see it in the list of cases, which is annoying. It goes straight to, oh, yes, I can. Sorry, I'm an idiot. There's a big gap, and it's because it's got Walton Stores beforehand, and I just thought that was the beginning of the W. 1393, let's have a look. Sorry, it's terrible when I go from the Paducah Institute. Because, you see, it's... sorry, I'm just looking at where it is. Wallace. Because the principles are kind of more important than the case examples. So, of course, then people like me forget about the cases because I'm more interested in how the principle works. Yeah. But that is not good for you when I'm confusing you.
Well, it might I mean, this internet website might be wrong. I don't know. I just want
to know. Look, it's the principle is what matters. I know we're right on the principle, but I can't remember how the facts fell through. 1393, let's have a look at it. All right, so this is a contra preferentum rule.
Yeah.
Okay, and so, all right, so basically what the contra preferentum rule is the rule that says if you have drafted the contract and it's capable of being read in two ways, one that is more favourable to you and one that is more favourable to the other person, then it's going to be read against you. So we're going to read it contra as in against, proferens, which is Latin for something to do with writing, the writer or the offeror. So in that case involved a contract for the sale of seed, which had been defined as common English sane foin. The sellers developed a different kind of seed, the giant one, and it was inferior under the contract. The buyers alleged a breach under the Sale of Goods Act, which provided that the goods need to correspond with their description. So the seller sought to rely on the exclusion clause, which provided the sellers give no warranty, express or implied, as to the growth, description or other matters. The word warranty may be used to mean any term in the contract, or it could be used in the strict legal sense to mean, this is where I've done it, sorry. I've been talking about the description of the seed as being the thing that was construed narrowly or broadly. It's actually the term warranty that was being, sorry, I am an idiot. I'm so glad you didn't go away, Sarah, because it's the same principle, but there's two ways. It's basically saying there's two ways of reading the word warranty. We can talk about it in the general sense of it's a promise that's made under the contract. And you will have noticed a lot of, particularly Lord Denning uses that language. The warranty, he wouldn't have warranted this, he would have just said, of course, you have to check the logbook for yourself and that kind of thing. Or it can be used in the technical legal sense if a warranty is different from a condition. Here, the court is saying, because you drafted the contract, and there are two ways of reading that clause, one of them favours you, you could just basically use that if we use that term in the bigger sense to mean any condition, you have a better result, but we're going to construe it against you so that the description of the seed needs to match what it was that our seller was expecting to buy. Have I made it worse again, Sarah? So give no warranty could be read as give no promise at all, or give no warranty where it's only breach. Breach means damages.
I think I understand the facts and I understand the outcome, but I don't quite understand the reasoning.
Okay, well, that's the reasoning. The reasoning is the important bit, so let's make sure that we get it right. The reasoning, the important part here is that when a contract is in writing and it's capable of being read more than one way, then the contra preferentum rule applies. And that means it will be read against, contra, the party who wrote the terms.
Right.
So the idea, think about the legal logic there is, if you're the one writing the terms, then the inference it becomes more important to you to get the language exactly right, because it's going to be read against you. And for those of you who've had a look at sort of boilerplate clauses in the Encyclopedia of Terms and Precedents, one that pops up from now and then is a term that gets put into many agreements, which basically says just because somebody drafted this agreement doesn't mean that it should be read against them. So they're basically trying to get rid of that common law provision. So you see that in agreements all the time.
Does that work?
I'd actually have to go and have a look to see if there's been any cases where it's been considered. Give me 2 seconds, I can probably do that.
Like, surely they can't tell the judges how to, I don't know, that just seems like...
Well, But it's when it only really applies when there's two readings, right? No, not necessarily like an honour clause. So let's use this one, for example, where actually, no, that's going to confuse us more. If I've got a provision that says, sorry, I'm just trying to think of something that hasn't been judicially considered where I'm going to confuse you even more. I'm going naturally to things like best endeavours clauses. So if I've got a provision in a contract that says anything that needs to be done on a day needs to be done by the end of that day. And then later on, somewhere else in the contract, I've got the term day is defined as a business day between the hours of 9 a.m. and 5 p.m. in Victoria. So in this contract, any reference to a day means between 9 and 5 p.m. in Victoria on a day that banks are open for business. And so that meant if something had to be done by Saturday, then actually when you read the contract, say everything has to be done by the end of the month. So a clause in the contract that says if it needs to be done by a time, it needs to be done on the end of by the end of the day. If the last day of the month turned out to be a Saturday, then the thing would probably need to be done by 5 p.m. on the following Monday because of the way the definitions work. Sorry, I'm trying to set it up and hoping I get a good example out of this. I've written this contract. It's confusing. I'm yelling at you all the time that I want the numbers or the reports or whatever by the last day of the month, whatever day of the month it is. I've written the report, the contract the first time. I then argue that there's a difference between something being due on a day and being due on a business day. Without that clause, a court is likely to say, well, actually, we could read it either way. You wrote the contract, they're your terms to start off with, so we'll read it in the way that is more convenient for your customer or your supplier or whatever it is. With that clause in there, it would give me the basis for having an argument about it. So it's different from an illusory promise. It really just sets up to what things will we fight about if we're going to fight about the contract. And to be fair, people only fight about the terminology in a contract when the relationship is really broken down.
Mm. Would the clause have to specify like what second reading it was excluding?
No, because that's when it comes up is it's something you haven't contemplated.
Yeah.
So in the seed case, for example, my guess is if they're anything like my clients, they had a contract already, right? They've developed a new seed. They've got another contract that they've sold seed with before, and they've just used that one again without necessarily thinking it through. Or they specifically haven't mentioned to the lawyers that this something was important to them. So we'll look at a case, not tomorrow, but next week, depending on time. We'll probably talk about it in class. It's not even a particularly high. I think it's a single judge in the Supreme Court in Queensland, a case called Nifsan and Buskey, where we look at where people were buying an apartment near the Gold Coast, and they were very keen on getting some views, but they didn't actually specify the views in the contract. And they did some things and they got some information about, so they had an understanding about what other buildings were going to be built around them, but it turned out that information was false or misleading at the very least. And so they didn't want to go ahead with the contract. But they'd never actually put the words, we want to buy a flat with uninterrupted views in any of the, well, it had been clearly discussed in the negotiations, but it wasn't in the document. And so often, because agreements are what people, agreements are verb, agreements are what people enter into, but the agreement, the written document, that's the noun, that's the thing that a third party has come in and tried to sort that out. And sometimes the nuance or things you just didn't expect. Like I think there'll be lots of contract law disputes coming up shortly because there'll be lots of people who will not have been able to deliver under their contracts. I think those of you who are doing advanced contract law next semester, I think you're going to have a really good time with it because it's all about how contracts get broken and terminated. And it'll be really easy to envisage how completely unexpected things can happen that you couldn't have contemplated. Now, you know, just because your contract didn't anticipate that, you know, every cafe in Melbourne would be shut down, every cafe in the country would be shut down for a period of weeks, and you've undertaken to sell however many paper cups or napkins or goodness knows what, your contract doesn't lack certainty just because it didn't deal with the what do you do if all your customers are shut down. You just have to read it in a way that makes sense in that context. You look very worried, Sarah. That she's smiling now. Are you doing somebody else's homework while you're in this tute?
Oh, my daughter's just listing all. She's doing a family tree.
Oh, good.
Yeah.
Am I in there? Emily? Really? Can't I at least be like a little worm that goes into the family tree and, you know, creates a bit of weakness in your Sunday night branches? Just a little bit of compost under the family tree, perhaps.
No.
Okay, look, the whole point of these tutes is for us to have the conversations and to really make sure this works. So I feel like 2 for 2 today. I've set you off on the wrong track to an extent. But I still think the conversations are valuable and worth having. I went to my bookshelf before to grab this. I don't think this is online. This is Lewis and Hughes. You're way too early for it. It's eye-wateringly expensive. Like, you know, I think I'm talking about $400 in this one and only little volume here. But this is my go-to when I'm writing contracts because it literally goes through so many of those kind of provisions and those boilerplate provisions and really ekes out which ones of them have been considered judicially, what do they mean, where do you use them, where are the risks. So Lewison is an English QC, and so it was an English version, and then he's done it with Hughes, who's a Sydney-based QC, and this is gold. But yeah, not online. I'm not sure our library has it, but it should. But the Supreme Court Library does, and it welcomes students, and it's a lovely place to go and study when you get in there. Have any of you been in there?
I didn't know that was a library. That's so cool.
Yeah, students are welcome in the Supreme Court Library. You have to get your bags checked at the door and all the rest of it. You can't take photos when you're in there, but it's actually.
Oh my God! I just googled it. Wow.
It's beautiful because it's this really
cool.
The building itself, it's a Victorian building. It represents this idea that of the separation of powers, basically. So the courts themselves are completely separate from the law book. So there's a kind of round library in the middle and the courts go around the outside. I love the portrait of Marilyn Warren that's in there. So I can't remember his name, the guy who did it. It's Asher Keddy's husband. He won the Archibald at least once. But it's great. There's all these portraits of all of the old judges, and they all have a black background and they wear their red robes and everything. And Marilyn Warren she's like a feisty, fierce little woman. Like, she makes me look tall. She definitely makes me look fat, but she's on this kind of white background and she's there in her like killer heels and she's all in black and she just is ready. And it's just the most beautiful painting. It's just worth going in there for the art alone, but it's a nice quiet spot to work. And yeah, you never know who you'll see in those little corridors. I highly recommend it. And they have all the good texts. You can't borrow them, but you can find things.
That is so cool. Thanks, Kath.
Pleasure. It is. I will convert you all into being law nerds before you know it. All right, on that note, I'm hoping some of you are mum nerds and are going to at least kiss your mums for me, seeing I'm being mean. Am I leaving next term or just not doing contracts? I'm officially not on the roster next term, so I think Sunday week is officially my last class. I don't know what's going to happen. I assume, because I am completely vain, Marius, I assume when any other teacher takes over my beautiful subject that is so well organised and has my beautiful PowerPoints and gets to work with contract students, they're not going to give it back. So I'm assuming I'm outski. But in a bizarre twist of fate, giving you guys way more information than you need or is possibly professional, it turned out I was eligible for long service leave. So, which if I didn't take, I would lose because I'm a casual employee. And if I had a break of more than 4 months, which I'm likely to have, I would lose it. So bizarrely, because they can't afford to pay me to do this, they're going to pay me long service leave. So, winner. Anyway, but yeah, more information than you need. But yeah, that's my plan. So yes. Anyway, so I'm thinking.
I'll send a separate email just regarding like next term's the legal research thing that's happening.
The legal research project.
Yeah. Like
yeah, that's supervised by a proper academic. I'm a technical academic, not a proper academic. So, but yeah, look, I know they're cutting some classes. I think they're going to merge some stuff with online. I'm not exactly sure what they're doing, but look, it'll work itself out. And there's an exceptional team at GSBL. I reckon you guys will be fine. I'm a bit of a sook, as you can tell, but I think you'll be well and truly well looked after. And I've been threatening to make a podcast about contract law for ages, so it'll give me time to do that. Yeah, I'd be interested in you guys. I like the idea of having, like the desk lectures, only like more like a podcast and more a conversation. So either with a student, but you know, a student who's prepped, if you know what I mean, or practitioners about a range of different issues, but focusing it in, so it could be like a study skill thing. I don't know what I'm going to do, to be quite frank. I know I'll be busy. All right, lovelies. Unless we've got more, I reckon we've now got to 8:30, so it's time for me to open a bottle of wine. And happy Mother's Day to you, Sarah. Thanks for bringing your kids in to make it more amusing for me.
Oh, they really enjoy it because they know this happens on a Sunday night. So.
I actually think it's awesome. I know this is just me, but I think it's awesome when kids see their parents making effort at stuff for school and what a great role model. I think the more they see it, and if they see you enjoying school. And learning. My mother was a teacher, and she never enjoyed a minute of school, and I just, and she was really she was always cross about school. I just think looking at people who are actually working hard, it's so good. It's all very Carol Dweck.
And my daughter's just started reading since coronavirus.
Oh, really?
Yeah, she's really getting into it now, really enthusiastic about reading books. So
awesome.
Yeah.
Yeah, I think this time is going to make some families and break some families. It's going to make some students and break some students. Yeah, I don't envy you at this time having to supervise them at home and manage through all of the other things that you have to do. But at the same time, it's great for them.
Yeah, well, they might send them back to school soon. They're threatened to, aren't they?
Yeah, well, I know it's easy for me to be judgy because mine are, 21 and 27. So my poor daughter, I really probably shouldn't say this I'm going to stop the recording because we're finished, right? And now we're just chatting.